That's probably going to be it then, I think.
So I guess I will provide a brief introduction and then turn the floor over to Professor Ziegler. Professor Mary Ziegler is the Martin Luther King Jr. Professor of Law at UC Davis. She is an expert on the law, history, and politics of reproduction, healthcare, and conservatism in the United States from 1945 to the present. So I'm just borrowing a bit from her bio from UC Davis. She has authored numerous articles and 6 books on social movement struggles around reproduction, autonomy, and the law. I originally reached out to Professor Ziegler after having seen an article that she had written. I wanted to just remind the commissioners, one of the commission's decisions early on involved how we were understanding sex for the purposes of this study, and we were understanding that term broadly to include issues including pregnancy and reproductive issues. And one of the, I think, issues at the heart of this conversation that I'm hoping that Professor Ziegler will be able to provide some more information about is thinking about biological differences and equality. So I'm going to turn this over to her, and she's got her slide deck ready. So Professor Ziegler.
Thanks. Yeah, I'm going to give you a little background about how people have thought about reproductive issues, whether it's pregnancy, abortion, even trans issues in the context of ERAs, and then talk to you about some of the current debates that are unfolding that may inform your own conversation. So in the early struggles over the Equal Rights Amendment, I think it's fair to say that reproductive issues were sort of the third rail. So you would often see progressives and feminists arguing that the federal Equal Rights Amendment or even state equivalents would not lead, for example, to recognition for rights to access contraception or abortion, because it was perceived that that issue would prevent or short circuit the ERA ratification process at the federal level. And so it was an interesting sort of counterintuitive time when you would see conservatives like Phyllis Schlafly arguing that there was, in fact, a connection between sex discrimination and sex stereotyping and abortion or pregnancy. And you would see progressives suggesting that that was not the case, and that, in fact, the best way of thinking about reproductive issues was using some other constitutional framework like due process or privacy. And that, I think, continued for some time until the ERA ratification process stalled in the 1980s. There was a parallel process both in the 70s and I think more recently in states like New Mexico, where we've seen states that have in fact ratified their own ERAs, interpreting those ERAs to extend to issues of reproduction. They've done that in a couple of different ways, often in cases involving state Medicaid bans on abortion, right? Laws prohibiting Medicaid reimbursement for patients who have used abortion. The argument has been, I think, that either that abortion bans reflect stereotypes about gender roles and as such trigger concerns under the ERA, state ERA, or conversely, that there is a strong correlation between the sex of birthing people and abortion bans that warrants those laws being viewed as a form of sex discrimination. Again, this has triggered controversy even now. I think there's been a pretty active effort by the US anti-abortion movement in trying to once again stop a federal equal rights amendment or even some state equivalents by arguing that they will mean not only abortion, but Medicaid funding for abortion or limits on parental notification or consent laws, which is a harder argument to make. So what is the connection? I think there are different ways of thinking about it that we've seen progressives make, and they all kind of in one way or another draw on existing Supreme Court precedent on sex discrimination and reproduction. It's worth emphasizing at the outset that the US Supreme Court never formally declared abortion a sex equality right. So there is no abortion decision, there are no contraception decisions, there are no decisions on trans rights framing any of these kind of reproduction adjacent issues as sex equality issues. Instead, there are clues in the jurisprudence of reproductive rights, and especially when that jurisprudence is read against the backdrop of the court's sex equality jurisprudence. So Ruth Bader Ginsburg was really the architect primarily of this jurisprudence during her time on the court. And its central claim was that some laws reflect not genuine differences between persons of different sexes or gender identities, but rather stereotypes that were pernicious, overbroad, and archaic. She began developing this theory as a young attorney working for the American Civil Liberties Union and carried it forward to her time on the Supreme Court as a justice, particularly in decisions like VMI, Virginia Military Institute, which struck down a law that had limited VMI's adversative training, which was military style, very physical training, to male identifying students. Ginsburg had held, along with her colleagues, that this law violated intermediate scrutiny because it relied on generalizations about cisgender men and women and their capacity to, or even interest in undertaking certain exacting physical tasks. There are, of course, other theories of sex discrimination as well in the academy, particularly theories that intersect with the rights of queer and LGBTIQ Americans. Recently, the Supreme Court in 2020, in a case called Bostock, held that Title VII of the Civil Rights Act of 1964 also prohibits, in prohibiting sex discrimination, sexual orientation discrimination, and gender identity bias. As a result, there's an argument that sex discrimination always implicates gender identity and always implicates sexual orientation. And so there are theorists who've tried to elaborate more on these connections between sexuality and gender identity on the one hand, and sex on the other hand. The stumbling block, and where we've really seen conservatives be active in the aftermath of the Dobbs decision when it comes to equality and abortion, is what's called real differences. So this concept, I think, developed over time, but was first visible in a 1974 US Supreme Court decision that emerged from California called Geduldig versus Aiello. At the time, the California State Disability Program for governmental employees did not include coverage for pregnancy, although it did cover similar disabilities or conditions. Those challenging it argued that this pregnancy-based exclusion was sex discrimination under the Constitution as it then stood, at the time arguing that it reflected both sex stereotypes, right, that cisgender women who had children, or even other birthing people who had children, would stay home and take care of those children rather than returning to work. And they argued that most people who were birthing people were cisgender women, so there was a correlation between sex and pregnancy. The Supreme Court didn't buy that argument and held that pregnancy and sex were distinguishable, and that in fact, the differences California had drawn were based on real biology, not sex stereotyping. The Supreme Court would elaborate on this claim in a series of rulings on things like the rights of fathers of biological children who never married the mothers of those children, in cases about statutory rape laws, and much more. So this distinction was around in the Supreme Court's jurisprudence, but had been kind of chipped away at over time until the Dobbs decision. So Dobbs was not really supposed to be a decision about sex equality and abortion. Neither the petitioners nor the respondents in the case had actually raised the issue. It was only really amicus briefs that did so. But the court in Dobbs nevertheless reached out to address the issue and said that there was no equal protection justification, at least under the existing Constitution, for abortion. The court reasoned that that was the case because of Geduldig, essentially saying, if it's not unconstitutional to single out people who are pregnant, it shouldn't be unconstitutional to single out a procedure that only, as the court viewed it, only cisgender women and trans men, or as the court would say, only women or only one sex could get. And that effect, or Dobbs' holding on this, has sort of revived Geduldig and this idea of real differences on the right. So recently, as you know, states have been passing laws criminalizing the provision of gender-affirming care to trans youth. Some states have tried to extend those bans to adults. And And most of those laws so far have been struck down by federal courts, either because they violate parental rights or often because they are considered to be sex discrimination. The answer conservatives have given to this is essentially Dobbs and real differences, right? The idea being that if you can single out abortion or you can single out pregnancy, you can single out gender affirming care because it too has something to do with biology, pregnancy, real differences, the physical versus sex stereotypes. Of course, it's a sticky distinction, right? Because as Ruth Bader Ginsburg recognized many years ago, probably the dominant sex stereotype for many decades in the workplace was that birthing people don't go back to work after childbirth. So that was a stereotype centered on biology. So teasing apart real differences and stereotypes has not been easy, and I think is even more complicated in the aftermath of Dobbs. So I think as the commission is thinking through how to deal with these issues itself, these real differences cases or issues come up across a variety of areas that touch on sex equality. That includes sexual orientation discrimination, again, because both progressives and conservatives often describe sexual orientation discrimination as a form of sex discrimination. Pregnancy discrimination, again, there is no constitutional framework for analyzing pregnancy discrimination at the federal level. The case law we have is entirely statutory. So if there were to be an ERA, would have to be fleshed out what that means for pregnancy discrimination in the workplace. Certainly abortion as well. The leading candidate for a constitutional theory for abortion rights in a post-Dobbs era is one based on sex equality. So that too is a kind of potential real difference or not issue that will have to be fleshed out. The same goes for other reproductive services like contraception. It's less of an idle threat to think that there'll be laws regulating contraception, in part because Americans don't agree on the line between abortion and contraception or which drugs or devices function as abortifacients. Even in vitro fertilization and access to fertility technologies for those with infertility. So I can stop there and take questions, but as you can see, the intersection of reproductive issues and sex equality issues, I think, is even more visible now than it has been in recent decades.
Thank you, Professor Ziegler. I wanted to touch on the issue that you raised about kind of teasing apart stereotypes and real differences.
Mm-hmm.
Is there much case law or scholarship there on how to think about those issues? Can you give any guidance as to like things we should be looking at to think as we think about that?
Yeah, I mean, I think the best clue that case law has given us essentially is to look at the fit between the means and ends of a law, right? So if a state proclaims that there's a real difference and it seems to be using sex biased means in ways that seem unnecessary, that can raise a red flag. So for example, if you say the only way we can protect, or recognize these real differences is by drawing this sex classification, and you in fact can sit down as a commissioner and come up with 10 or 15 other ways that you could secure the same interest without drawing a sex classification, that may send up a red flag that there's a stereotype at work, right? If it seems that the state is saying one thing and that thing doesn't line up with what it's doing, that I think that can, it is hard though. I don't want to overstate how easy it is, especially because the most pernicious stereotypes are often tied to reproduction, right? And reproduction is an area where there are real differences. I think at the outset, a good sort of starting point is to notice that fact, right? And to say that just because this is an issue involving pregnancy or birthing capacity or identity assigned at birth or any number of the things that look biological, that doesn't mean stereotypes are not at work. Some courts and scholars have also looked at what we would consider sort of history and motive. So if there are lawmakers in the lead up to the passage of a law making biased statements or airing stereotypical views, that can signal that a stereotype is at work. But that approach too has flaws, right? I mean, requiring motive or focusing on motive is always challenging in law, as you well know. It's often very hard to prove motive or intent, even when it's present. So I think a lot of scholars resist that as a dominant framework, but that can certainly be a helpful supplementary approach. It's certainly one that's pretty developed in the case law. But I think that there's been, I think, at least Justice Ginsburg and other scholars have said essentially, we should not be treating cases where there is a real difference claimed any differently than any other sex classification, which is to say, the government should always have to show its work. It should always have an exceedingly persuasive justification for what it's doing. And it should always carefully tailor the law to make sure it's not writing sex classifications into the law when it's not necessary to do so. I think the tension now is whether Dobbs has changed that, right? Whether Dobbs has said there's this biology carve out, and if you can plausibly make whatever you're talking about biology, we're not going to make the government show its work anymore when it comes to sex classifications. I think that would be dangerous, but those are some of the approaches I've seen in the case law.
Thank you. Commissioner Carrillo.
Yeah, I had sort of a point and a question. The area of the law that occurred to me when Kristen was talking about whether anyone has built out a body of law on real differences is from employment law. There's the idea of the BFOQ, bona fide occupational qualification. That seems to me that's the first thing that occurs to me as somewhat analogous. I mean, it's not on all fours, but it's close. So for example, if I wanted to have a baby, someone could say, there's a real difference here. In order to do that, there's this occupational qualification of having, the biological equipment in order to have a baby. You can't do that, so the law is going to discriminate against you on that basis. And I think that the major point that you made here is that the question is whether it's invidious discrimination, because the law discriminates on legitimate bases all the time. The question would be whether discriminating against me because I don't have what's required to have a baby, whether that's invidious or legitimate.
Mm-hmm. Yeah,
so I was just wondering if you looked into employment law.
Yeah, I mean, I think that's a great analogy. And the bona fide occupational qualification analysis dovetails a lot with what true intermediate constitutional scrutiny looks like. Like, I think the Briner decision, which is a California decision, is a really good example of that, because the BFOQ analysis is pretty demanding, right? Because again, it's easy to say, there's a real difference here when that's not really going on. So for example, the Briner decision was about correctional officers, and the Department of Corrections, this was in Nevada actually, had said, we have a history of male identifying security officers sexually assaulting female prisoners. So at high levels of administration, we're only going to permit female correctional officers to serve in kind of white collar positions in the prison because of this history of sexual assault. And the court, I think, said, while this is stereotype based, right? There's an assumption that some people commit acts of sexual assault and some people don't, that some people are victims of sexual assault and some people aren't, and there isn't a very good fit between the means and the ends, because there was no, for example, requirement that only correctional officers who see prisoners disrobed or who even have in-person interaction with prisoners have a particular sex or gender identity. It was people in administrative positions who would not have any of that kind of contact anyway. So that's another good model, I think, because it accounts for the fact that there are real differences that are not invidious, but also that those real differences are often weaponized, right? And that people can attach stereotypes to them and then say, nothing to see here, we're talking about biology, because both things happen in the law quite often.
Thank you. That was very helpful. The question that I had was whether, so one of the things that the commission has to wrestle with is, should we do something, and if so, what would that look like? Mm-hmm. And one of the threshold issues on the should we do something question is whether the law around sex discrimination writ broadly has spread widely enough that the kinds of things that we would be concerned about capturing with a California equivalent of the ERA, whether those things are already captured by the existing equal protection analysis. And I was just wondering if you have a thought on what's missing.
Yeah, I
Again.
mean, I think the answer is difficult because it's in flux, right? So, I mean, Reva Siegel has this famous paper from the 2000s called The Case of the De facto ERA, right? And her argument essentially is that the Equal Protection Clause already encompasses a lot of what the framers of the ERA wanted. Even she acknowledges that that didn't encompass, and this is, circa 2007, 2008, right? So we're talking about, so even then there were things that were left out. I think especially things related to the topic we're talking about, right? I mean, things like, you can have a statutory rape law, anything involving sex or reproduction, like sexual assault, abortion, pregnancy, birth control, none of that would be included. Even at the kind of high watermark of the Ruth Bader Ginsburg era of sex equality jurisprudence, none of that was in. Having said that, we're not there anymore, right? So I think what sex equality jurisprudence looks like is quite likely to change in the same way that substantive due process jurisprudence already has. So I think if the commission is thinking about its work, it has to think about sex discrimination jurisprudence as being in flux, given the composition of the Supreme Court. And given that circuit courts are already reading Dobbs to revolutionize sex discrimination jurisprudence. So another thing that was worth mentioning about that Sixth Circuit opinion, the Sixth Circuit opinion cited as the kind of relevant standard for sex discrimination jurisprudence Reed v. Reed, which is not usually thought of as the main rule of law, but Reed v. Reed applies basically a rational basis to sex discrimination across the board. So essentially they were saying Dobbs not only makes clear that you can discriminate on the basis of anything that looks sort of like reproduction, even when there may not be a real difference present, you may not just have to worry about sex classifications as much, period. I don't think Dobbs said that, but the fact that, a panel of the Sixth Circuit Court of Appeals is putting that argument out there, and that lots of conservative lawyers are making it, means that I think we can't take for granted that the sex discrimination law we have today is the sex discrimination law we will have a year or two down the road. So I think if anything, that probably makes it more important for states like California to develop something like the ERA than it would have been before, just because we have a very different federal constitutional and judicial landscape than we did a while ago.
I think that's one of the things that I'm held up on is that for as much as federal law is in flux, California's equal protection law, particularly as it relates to sex and gender discrimination, is untethered from federal law.
Right.
For example, we don't have intermediate scrutiny, for example, and there's no signs on the horizon of California Supreme Court ever adopting intermediate scrutiny.
Right.
So, so if anything, the more in flux federal law is, and to the extent there is a trend that we can see, it's, it means that it's diverging from California law, so that, ultimately what it means is that California law is going to be more distinct than it already is.
Right.
So, so that's why I'm stuck on what would we do in California to make it more robust than it already is? If anything, by comparison with the shrinking federal law, it's only going to look better.
Yeah, no, that's definitely true. And I mean, so there may already be the equivalent of a state ERA in California. I mean, I think it feels in some ways kind of parallel to the conversations about Prop 1 that unfolded recently. I'm sure, as you know, people were saying California already has really robust statutory law protecting reproductive rights, and it already has really great jurisprudence from the state Supreme Court. And I think there was a sort of a desire, I think a recognition that it could be better, right? That some of it was old and kind of felt like it was written by people who had not lived through because they hadn't lived through the past several decades of interactions about what sex discrimination means in a bunch of different contexts. But I think there was also an aspect of it being an important insurance policy, because I mean, do I think there was, a strong need for Proposition 1? Not really, in the sense that, do I think there is a future where the California legislature and California Supreme Court passes a ban on abortion at fertilization? Like, no, I don't, right? But I don't think that made Proposition 1 a good idea. So I think there's sort of a parallel conversation happening here, where certainly I don't think there's, a desperate need, in the sense that California jurisprudence on sex discrimination is robust and is different from federal law. But there may be areas where either where you want to have a backstop, like a state constitutional backstop, or where you think that the case law is a little bit out of date or doesn't directly touch on some of the issues we've been discussing.
I think Prop 1 is a very good example here, because one of the concerns about Prop 1 was, does it do anything new and different? And if so, what would that be? And if it doesn't do anything new and different, why are we doing this? And so the needle that people try to thread in arguing for its adoption, and it did pass, was essentially codifying existing law to prevent future changes. So, you know, and I sort of see that's the direction that this conversation about a California version of ERA going, is codifying existing law, which is already pretty good.
Yeah, and maybe improving on it, right? Because I think, for example,
would that be?
California has a viability limit. It's a lot of the jurisprudence and statutory stuff was very like in the privacy, like you have a right to choose, like 1990s safe, legal, and rare kind of tone. It was disconnecting abortion from other issues like forced sterilization. So it was sort of less clear whether a reproductive right would extend to other reproductive issues. And so it wasn't necessarily that what California already had was bad, but there was a sense both that it would be nice to have this insurance policy, and while we were at it, it would be good to actually basically do better than codifying the status quo. I think there's sometimes a feeling that as much as California has diverged from federal law, there's still room for improvement and updating. So I think, I mean, and that's, I think, was the other argument for Prop 1, that there was a sort of more robust understanding of what a reproductive right or reproductive justice could be than was already present in California law. And that that was what would be, you know, kind of at the state constitutional level, rather than something that was, you know, perfectly fine and probably not super different in terms of the substantive outcomes that it would deliver on most issues, but something that would be clearer, easier to understand, and covering some of the areas where there may have been missing pieces, like sterilization being a good example, where there had been, you know, there had been forced sterilizations in California in prisons in recent years, and that people had not understood that as a violation of reproductive rights because they hadn't connected the dots.
Yeah, thank you, Professor.
So I just want to check and see any other questions from commissioners, audience members.
No.
Right. It looks like we're up on the time that Professor Ziegler has offered, and I greatly appreciate his learned a lot, and really appreciate you taking the time to come and join the commission meeting and share all the information with us. So,
Of course, happy to help. Thanks, everyone.
Thank you, Professor.
Do we have any other business?
No.
I think we are.
Move to adjourn?
Second.
Provisionally.
Provisionally.
I'll ratify it next time.
Thanks, everyone. See you in
Okay.
October.
Thank you for the room, Cara. It worked
Yeah,
well.
thanks, Sarah.
No problem. Take care.
All right. See you all in October.
We need to disconnect this one.
No.